A police officer stops you on the sidewalk. He hasn't seen you commit a crime. He doesn't have a warrant. He couldn't get one if he tried. And then he runs his hands along the outside of your clothing, looking for a weapon. For most of American history, that would have been almost impossible to justify under the Constitution. Today, it happens thousands of times a day, and it's legal. The question is how we got here. How sure does an officer really have to be before he can stop you and search you right there on the street? This is the story of Terry v. Ohio, the 1968 case that created one of the most powerful and most contested tools in American policing, the stop and frisk. One note before we begin: this is legal history and education, not legal advice. Start with the promise the Fourth Amendment makes. The government cannot search you or seize you unreasonably, and normally, before the police invade your privacy, they need a warrant, signed by a judge, or at least probable cause, a solid fact-based reason to believe you've committed a crime. That's a high bar, and it's meant to be simple. It stands between you and the raw power of the state, but the street is faster than a courtroom. An officer on patrol sees something that doesn't look right. There's no time to find a judge, and the person he's watching hasn't clearly done anything yet. So the law had a gap in it. What can an officer do in that in-between moment before there's ever enough for an arrest? For decades, the answer was uncertain. A single afternoon in Cleveland forced the Supreme Court to fill it in. October 31st, 1963, downtown Cleveland, mid-afternoon. A plainclothes detective named Martin McFadden is watching the street. He is not new at this. He has been a police officer for 39 years, a detective for 35, and he has patrolled this exact stretch of downtown, hunting shoplifters and pickpockets for 3 decades. When McFadden says something looks wrong, it is the judgment of a man who has watched this corner for most of his life, and something looks wrong. He notices 2 men, Terry and Richard Chilton, standing on a corner. One walks down the block, pauses to stare into a store window, walks a little farther, turns, and stares into the same window again on the way back. Then the other man does exactly the same thing. Back and forth they go, taking turns, roughly a dozen trips past that one store, pausing each time to look inside, then returning to the corner to confer. To McFadden, this is not a couple of window shoppers. This is men casing a stick-up, studying a target before robbing it. A third man briefly joins them and leaves. And a robbery, McFadden knows, usually means a gun. He decides he cannot just watch. He follows the men down the street. He approaches, identifies himself as a police officer, and asks their names. The men only mumble something back. And in that instant, McFadden makes his decision. He grabs Terry, spins him around, and pats down the outside of his overcoat. He feels the shape of a pistol. He reaches in and pulls out a loaded .38 revolver. He frisks the others too and finds a second gun on Chilton. Terry is charged with carrying a concealed weapon. He's convicted and sentenced to 1 to 3 years. And that's where the real fight begins. Not over whether Terry had a gun, but over whether the officer was ever allowed to go looking for it. Here's the problem. At Terry's trial, the judge said something remarkable. He admitted that McFadden did not have probable cause to arrest these men before he searched them. There was no solid case yet. So if the officer couldn't have arrested Terry and couldn't have gotten a warrant, how could reaching into his coat and taking his gun possibly be a legal search? That was the question the Supreme Court agreed to answer. Does the Fourth Amendment let a police officer stop a person and search him for weapons on something less than probable cause? Or is it all or nothing, full justification, or hands off? Chief Justice Earl Warren wrote for the court, and he began by refusing an easy escape. Some had argued that a brief street stop isn't really a seizure, and a quick frisk isn't really a search. So the Fourth Amendment simply doesn't apply. Warren rejected that flatly. When an officer takes hold of you and runs his hands over your body, you have been seized, and you have been searched. The Constitution is in the room, and this is the pivot of the whole case, that didn't mean the officer needed a warrant or probable cause, because the true command of the Fourth Amendment, Warren said, isn't the warrant. It's a single word: reasonableness. And reasonableness, he decided, could stretch to cover this in-between moment, if the law drew the line carefully. To see what the court did, picture a ladder of certainty. At the very top is the standard to convict you of a crime. Proof beyond a reasonable doubt, near certainty, the rule from a case we covered last time, in Winship. A step down is probable cause, enough to arrest you or to get a warrant. Terry asked whether there was a rung below even that, a level of justification low enough to act on a street corner, but real enough to keep officers honest. The court said yes, and it gave that rung a name: reasonable suspicion. And it defined it with a phrase that still governs police work today. To justify the stop, Warren wrote, the police officer must be able to point to specific and articulable facts which, taken together with rational inferences from those facts, reasonably warrant that intrusion. Read that carefully, because every word is a limit. Specific facts, articulable, meaning the officer has to be able to say them out loud and defend them. The test is objective. Would those facts warrant a man of reasonable caution in the belief that action was needed? What the law will not accept, Warren said, is a decision based not to his inchoate and unparticularized suspicion or hunch, but to the specific reasonable inferences which he is entitled to draw from the facts in light of his experience. A hunch is not enough. A reason you can name might be. And why allow even this much? One answer above all: safety. An officer investigating a possible robbery may be standing next to an armed man. So the court permitted a frisk, but a narrow one. It is not a search for evidence. Its sole justification, Warren wrote, is the protection of the police officer and others nearby. A pat-down of the outer clothing, for weapons, and nothing more. Apply that to McFadden, and it fits. He didn't act on a whim. He could point to specific things: the repeated casing of the store, the pattern of a planned robbery, the reasonable fear of a gun, all read through 30 years of experience on that corner. That, the court held, was reasonable. The vote was 8-1, and so the rule was set. In Warren's words, where an officer reasonably concludes that criminal activity may be afoot and that the persons with whom he is dealing may be armed and presently dangerous, he may conduct a carefully limited search of the outer clothing of such persons in an attempt to discover weapons. Stop and frisk was now officially constitutional. Put it back on the ladder, beyond a reasonable doubt to convict, probable cause to arrest, and now at the bottom rung, reasonable suspicion, the lowest level of certainty at which the state is allowed to lay hands on you at all. Terry didn't just decide one case. It drew the floor beneath every street stop in America. But one justice refused to sign. William O. Douglas dissented, alone. He agreed that Terry had been seized and searched. What he could not accept was letting it happen without probable cause. Because, he pointed out, a judge could not have approved this search. No magistrate can issue a warrant on mere suspicion. So the court was handing the street officers a power greater than the power it gives judges. Douglas saw something dangerous in that. To give the police greater power than a magistrate, he wrote, is to take a long step down the totalitarian path. Maybe such a step was necessary to fight crime, he allowed, but if so, it should be the people's deliberate choice, written into the Constitution, not granted quietly by a court. Over that lone dissent the majority held. Douglas lost the vote, but his warning named the tension that has followed Terry ever since. Because a standard as flexible as reasonable suspicion lives or dies on how honestly it's applied and who it gets applied to. That's why Terry is not just history. Its power runs through modern policing, and so does the debate over it. Aggressive stop and frisk programs built on Terry have been challenged for falling unevenly on minority communities. And this is not a new observation. The court itself, back in 1968, noted in a footnote that street stops were a major source of friction between the police and minority groups. The case created a tool and left the country to argue ever since about how it should be used. Step back and you can see the whole architecture. The law does not ask the state to be equally sure at every moment. It builds a ladder. To take your freedom for years, it must be nearly certain. To arrest you, it needs probable cause. And to stop you on a sidewalk and check you for a weapon, Terry says it needs a reason it can name: reasonable suspicion. Each rung is a different answer to the same question. How sure is sure enough? So the next time you see it happen, an officer, a quick stop, a pat down on a street corner, you'll know it isn't lawless and it isn't unlimited. It sits on the lowest rung of a ladder the Supreme Court built one afternoon in Cleveland, out of a detective's hunch that turned out to be a reason he could name. Where exactly that line should fall, how much suspicion is enough, is a question the country is still arguing. If you want to keep understanding the rules that shape that argument, one case at a time, consider subscribing. Thank you for watching, and remember, this video is for education and history. It is not legal advice.